a brief about Karana before I start sharing my presentation. Karna essentially came together trying to look into the evolution of digital governance around Aadhaar and how Aadhaar essentially, there were a lot of claims that came around Aadhaar, and we are a bunch of technologists who came. Most of them are technologists, but it's a mixed group of designers, social engineers, and you're welcome to join us. We have a public group, a public Telegram group it's, the link for it is on the HashGeek registration page, but I can even type it in the chat. So that's a brief about Karna. So I'm just gonna start doing the screen share on a bit about ICJS. So the reason we are discussing this topic is because it's kind of in the news of late, because some of the higher judiciary officials were mentioning this. So what is the integrated criminal justice system? But unlike what's in the news, it's not something that's coming out of the judiciary. It's something that is coming out of the Ministry of Home Affairs. So the integrated criminal justice system is interlinking several e-governance projects. It's interlinking the e-courts project at the judiciary, the e-prisons project with the prisons department, the e-police project, essentially digital police project, which there have been many, but the previous one before ICJS was the CCTNS, Crime and Criminal Networks and Systems. So you have the e-forensics, essentially all the forensics laboratories in India are interconnected. And you have the e-tribunals, e-juvenile justice. So you're interlinking a lot of these e-governance systems to create, according to MHA, this is not something that I am saying. According to MHA, they're using this to create 360-degree profiles of everyone inside the criminal justice system. Now, what would this interlinking of system look like? It will look like essentially a series of dashboards. If we're talking about data and data-driven governance, this is about allowing different arms of the criminal justice system to access each other's details via dashboards. I'm going to show you some of these dashboards, at least from what we know from some of the publicly available Ministry of Home Affairs presentations. So as I was saying, ICJS essentially is a central repository of every individual in the criminal justice system. It's being implemented by the MHA. Essentially, the NIC, National Informatics Center, is the one developing it. But the governance control at some level for all the data is at the MHA. There is oversight by NCRB. I don't think I should call it oversight, but some level of interaction between MHA and NCRB, which is part of MHA. And you have the judiciary's involvement because of the e-courts projects, because it's the judiciary which maintains the e-courts project. So that direct involvement, it's happening under their direction at some level as well, but it's being implemented by the MHA. And so the important question is, if you're trying to link these databases, right? Like essentially all of these e-governance projects are databases. So how do you do that? You have to interlink them based on individual's unique identity. That's the only way you can interlink these systems. Otherwise, it's hard to say track someone who's already a prisoner, who's already in the prison, but who has committed a past crime, or suddenly the police found out that a past crime which they were investigating elsewhere is also linked to this person. The only way you can match all of these is if you can uniquely identify this individual inside the criminal justice system. So I'm not going to say that it's entirely based on Aadhaar, but the idea essentially is that you have to uniquely identify every individual in your criminal justice system. So this is how it looks like. It's a visualization that I took from MHA magazine. It's listed in the reference section on the registration page, there are a bunch of documents that if you want to go check back, you can find this. So the ICJS system essentially, as I was saying, is going to interlink e-courts, CCTNS, e-prison. You have the prosecution, which is essentially the Department of Ministry of Law, I guess. And you have the forensic laboratories, and you have access for other agencies like the National Investigation Agency, which can use this data to identify criminals. But all of this is based on what is called pillars, which is basically each of these systems become a pillar, like police becomes a pillar, courts become a pillar, prisons become a pillar inside the criminal justice system. What does this allow? It actually allows a pan-India-wide search of criminals inside the criminal justice system. So search across the pillars data of CCTNS, e-courts, e-prisons, prosecution, NIA, etc. So they're using at some level NLP to try to text mine some of the court records and trying to generate some analytics here. So it's the MHA which says every other time that this is going to allow 360-degree profiling of persons involved in various pillars and facility to tag or exchange the profile. And this is interesting because this whole idea of 360-degree profiling at some level, it emerges post the initiation of the Aadhaar project for the state resident data hubs, or even part of CCTNS, right? CCTNS was, okay, I'll get to what CCTNS is. So yeah, so if you're talking about the history of police databases in India, India has a vast history of policing documents, but most of them are not really organized. But the idea of using fingerprints in policing goes back to colonial era. But what I know to some extent is the modern police digitization efforts at some level took place inside various departments within MHA. But at the state police level, you have the AP police interconnection of police stations around 2002, 2003. This is the time when e-governance efforts were at a peak level in India. All of this was before the National E-Governance Plan. And the Delhi police got its own network called the ZipNet network. Excuse me. So then you have the CCTNS project, which comes out in 2009. It was part of the National E-Governance Plan. Then the Integrated Criminal Justice System takes over CCTNS project in 2015. So essentially, the Integrated Criminal Justice System is an evolution of CCTNS. And because also the CCTNS project was getting delayed, and it was the Ministry of Home Affairs which actually proposed to the Cabinet Committee on Economic Affairs to extend the CCTNS project and to further fund the ICJS project around 2015. This is when the Cabinet actually approved it. So the CCTNS is essentially the interlinking of all police stations. This happened in the backdrop of the Bombay attacks, okay? But it's the origin of interlinking of police stations is not something new. People always knew that there were issues of inter-police department data sharing, like AP police won't share information with Tamil Nadu police, even though there could be issues at the border between these two states, right? So the information was always in silos, and this kind of posed a problem for MHA. So CCTNS kind of comes through the National E-Governance Plan, but it kind of gets fast tracked around because of the Bombay attacks. So you see that they're trying to interlink all of the police stations, and it actually started with the coastal police stations because coasts were kind of the large threat at that point of time. There are a bunch of documents around this within the parliament if one wants to look at this history. But so the modern CCTNS database, again, it's essentially a network, right? It's a crime and criminal tracking networks and systems. So it's similar to ICJS network. how ICJS is a network of various databases, you would find that CCTNS is also a network of all police stations. So at the base layer, there is a data sharing platform between police stations. But on top of that, each state police can collect information on their own. They can basically do more than what the MHA wants them to do. So the CCTNS at the base layer, part of its network, you have the missing children database, because the children, when they go missing, it's not necessarily that they are in your particular jurisdiction. There are interstate gangs which are involved in this. So when the missing children database came in, it got integrated into CCTNS. But this, at some level, the system is also with the Ministry of Women and Child Development. The other important system the CCTNS has is essentially they have this fingerprint recognition system with all the fingerprints which they have collected for forensics. The upcoming system that's part of CCTNS is facial recognition system. You have Vahan database, which is linked to CCTNS. You have FASTag that's also linked to CCTNS. So any of the modern systems, identity databases that are coming up, they're linking them to CCTNS. Again, going back to ICJS now, ICJS as the post CCTNS, I think the MHA understood how important for it to interlink databases. So which is why they also kind of propose this interlinking of prisons and police departments, because CCTNS is only interlinking of police. It doesn't look at data that's already available with the prisons department or with the juvenile justice divisions or courts. All of this is on the backdrop of fingerprints databases. So this is how the information flow looks like. So within the CCTNS, you have FIR numbers, you have case details. At the courts, again, you have the case number, you have the FIR number. But when the prisoner, say when the individual gets transferred from the police to prisons through court, he gets a prisoner ID. Also, in all of this chain, the moment you are part of this criminal justice system, they try to collect your fingerprint details. So this data becomes an important way to identify individuals. So the way to uniquely identify individuals is, again, not necessarily on Aadhaar, but it's based on fingerprints, and because that's what the MHA has been doing for a really long time. This information is again intershared with the forensics department. So you have a integrated data sharing of across the criminal justice system. This is the data flow that happens. So this is from a presentation by an NIC official who was presenting it to the MHA. It's actually available on the registration page. If you're watching it on YouTube or from elsewhere, you can go to the registration page and check the documents over there. So not all information goes to everyone, okay? So if you look at, say, fingerprint data, it doesn't go to the court, but it does go to the prisons department. It goes to the forensics department. It doesn't, again, go to the juvenile justice. So you have, at some level, information is being shared on a need-to-need basis, but it's being centralized at the MHA. So this is what the ICJS dashboard looks like. When you have to submit information of an individual, you submit his personal details, his Aadhaar number, PAN card, email ID, phone number, driver's license, his FIR numbers, part of the jurisdiction where they are, the courts, the forensics laboratories, prison details. And once you go into the system, again, this presentation was made much earlier, I think around 2015, when they probably proposed this project. We don't know in what form it is right now, but this is the idea that they had in mind. So when you click an individual, you get all of his details from his passport, Aadhaar number, email ID, voter card details. Again, see, some of these requirements of data collection is important because if you are indeed a criminal and a prisoner, your voting rights are taken away, right? So they need to actually supply this information to the election commission so that the election commission suspends his vote right. So I am not sure if how that information sharing is happening here, but that actually happens. The election commission gets a list of all people, criminals, and they actually remove them from voter lists. So when you click on an individual, you get all of his details, and accordingly on different modes, depending upon which administrative official you are, whether you're from the President's Department or the courts, you get access to different information. So when you click on police, you get access to witness details, the accused, the victim, the arrest details, the bail details, transit remand, criminal history, charge sheets, complaint details. So essentially, when you're talking about building these 360-degree profiles of individuals, so you're building those via ICJS, and this is how this information looks like. So when you click at prison, you get his prison ID, the FIR number, again, accused. Interestingly, they track visitors. So if you have visited any criminal in a prison, so you will have to, currently you'll have to give your Aadhaar number. While they could say it's not being, it's not mandatory and all, but they actually force you to do submit it. So you have co-accused so that you know who are the partners, and you ensure that you're not put together. I don't know what sort of protocols they use, but essentially this information is being tracked. So if you are on bail or parole, your details are there. Essentially, this information then goes to the nearest police department to essentially track the individual because he's on bail or parole. Movements to hospitals, inter-jail movements, all of this is essentially, which is tracked part of the e-prisons project, is now integrated with the ICJS project. So when you look at the court, you get details about the case, the summons, case transfer details, appeal stage details, court disposal, status of trials. So you also get what jail details. So for a judge, he actually gets to know what the police department is doing, what the prisons department is doing. So it's a nice data for a judge to actually understand the case better, I guess, or to understand criminal history of an individual. So at some level, I think you're going towards this model where within the US criminal justice system, you've started seeing you're rating criminals, right? A potential for a crime to re-happen of an individual. At some level, you are trying to profile these individuals, and we're not sure if they're going to rate them or if this is going to affect a judge's decision to whether to give him bail or not. But it's all being tracked. So again, the fingerprints to pillars. This is the information that's being shared to all the divisions. It's important to understand when you become part of ICJS, there is a permanent identification number that's being created. Okay, and I'm not saying this is Aadhaar or anything. So the Criminal Justice Department, essentially the MHA in this case, is creating an ID for you, which is the ID that they want to use to track every criminal. So that's the ID, your personal details, your provisional crime numbers, court cases, conviction dates, jail number, jail admission numbers, fingerprints. And the way to create the permanent identification number essentially boils down to fingerprints. So the moment you become part of any court case, whether you're being investigated, your fingerprints will essentially be collected. And that's the basis for the permanent identification number. So what's the current status of ICJS? It was proposed in 2015 to the cabinet. You have pilots that have been happening in Telangana, Delhi, Odisha, Bihar, and Rajasthan from 2018, 2019. So these are the 5 known states that already have this implemented. I think they're scaling it up now because for this to work, you have to have every other state's police departments, business departments to be interconnected. But what's actually live currently is the national search, for already existing criminals at the NCRP through the digitalpolice.gov.in portal. So if you are from the police department or any of the departments which are part of ICTS, what you could do is you could visit the digitalpolice.gov.in and you can start searching for criminals who are part of the criminal justice system. But ICJS is not just about the e-prisons, courts, or CCTNS anymore, because CCTNS itself is being interlinked with missing children's database, the driver's registration databases, vehicle registration databases. Even though you're not a criminal, you're becoming part of this criminal justice database because they're linked to CCTNS. Like, you may not be a criminal, but because you have a driver's license and you have a vehicle that you have registered with the government, and that's being linked to CCTNS, they can pull this data on you at any point of time. So it's not no more about criminals or people who have committed crime. It's essentially anyone who's going to be interacting with any criminal, if you're visiting them, or even if you're an individual who is potentially has challans, right, like vehicle violations through Vahan, all of that gets integrated into the criminal justice system. They have plans to link immigration and passport data. We are not yet sure to what extent this has happened. Why is this important, right? Like, what happened in Telangana, for example, this national search that they have to allow people to search criminals kind of was piloted at some levels in Telangana. So what they essentially did, the Telangana police kind of went overboard and started profiling every individual on the street. So when you become an accused in a crime, the first thing, as I was saying, they would collect your fingerprints to know if you're an existing criminal. But with access to these systems, what the Telangana police did is they actually went on the street. They asked every individual who looked suspicious to give their fingerprints. So I think by 2015 or 2016, MHA had this national automated fingerprint recognition system, which is part of CCTNS that went live. So you have the police department in Telangana, part of the pilot in 2018, doing all of this, right? Like, so in Telangana, the moment you enter a police station, your fingerprints are recorded to identify if you have a criminal history, and that happens through the ICJS network. Then you have the automated facial recognition system that's upcoming part of CCTNS at the national level. But again, the pilot for it has already began in Telangana. And what you've witnessed in Telangana is that post biometrics, which they were doing it as early as 2015, 2016, because the system went live in those days. But the facial recognition system kind of went live in 2018. So you have every police with a mobile tab who could identify anyone on the streets. But the problem is not that ICJS is limited to criminal justice criminals or people who are part of the criminal justice network. It's interlinked to everything, because in Telangana, what you're witnessing is the police department not only has access to ICJS, because all of this is at a base layer, right? Like, policing is a state subject. Each state can essentially do whatever they want. Each state police can go collect more details. So the Telangana police essentially uh, got access to everyone's details because Telangana has this new facial recognition based digital ID system. And that kind of actually came out because the police wanted access to data of every individual in the state. So these 360-degree databases, like if you're talking about the upcoming facial recognition system, while they're all saying that it will be limited to criminals, but what we're witnessing is that increasingly the police, the MHA, the NCRP is actually asking every other department to start sharing information. So if you already have a driver's license, you're part of their network because your photo details that are collected by the Ministry of Road Transport is already available for the MHA. I'm not bringing in Aadhaar anywhere here. We don't have to go into that conspiracy theory that it's all Aadhaar data, but it's identity data, right? Like any form of identity details, it's biometrics at some level, which are at the heart of this. Whether it's your photo through facial recognition, whether your fingerprints, it's being collected. All of this is being happening without a law. This directly violates the Supreme Court judgment on the right to privacy and the Supreme Court judgment on Aadhaar, where the judgment essentially says that there is no possibility of building 360 degree databases in the country, right? Like extensively, the idea of 360 degree databases were discussed during that judgment, and the judiciary ignored it. But anything and everything that was discussed heavily in terms of these 360 degree databases that most people feared might happen is actually happening, and it's all live. And essentially, ICJS at the end of the day is yet another 360 degree profile database. And you're going to see more of this that are going to happen, not necessarily from an economic welfare point of view. This is actually from the surveillance point of view for the MHA. I'm going to open it up for discussion. I think we have Prasanna here, who is, I'm just also going to end the screen share, who can answer some of the legal questions if you have any. But essentially, the idea is that this system is going to help the police with data analytics. That's their main pitch. And it's going to help them do preventive detentions in a better way. I think I'm going to allow you to participate by unmuting yourself. If you have any questions, please feel free to raise a hand and I can call your name and you can unmute yourself. Prasanna, I wanted to ask you this. Why is the judiciary so excited about this? Right? Like we know that the judiciary was so excited about the e-courts project. I would say it did bring some transformation of getting out judgments in an easier way, right? Like you could go check the website and you get the judgment. But again, they know how to evade it. Like my own case in Telangana, I had to pay 2,000 rupees to get the judgment because they wouldn't upload it because it's a very sensitive case. So there are ways they do it. They evade this accountability. But why is there so much excitement within the judiciary about this, even though it's not the judiciary that is building it?
Well, I mean, there is a short form answer and there is a long form answer. Right? Short form answer is that they've really not considered this judicially. Right? They think this is something that is going to increase their efficiency because there is so much criticism about how inefficient our judicial system is. So they say anything that promises to even correct that, there is a tendency to jump at those solutions. Right? I believe when this gets considered judicially, looking at what are all the problems and how it affects rights of people, the answer may be different depending on who the judge is and who the bench is and what their judicial philosophy that they bring to the table is and all of that. But as I said, so there is, and the present Chief Justice of India, we know he has talked about AI quite a bit, and in fact, trying to employ AI to solve various kinds of problems. So that's the thing. So the tendency is that you have this problem, these mountains of cases that need to be closed soon, and then you something that promises to make your system efficient. Yes, there is a tendency to jump at that and say, this is something that we need to try out. And specifically during COVID times, because that seems to be the flavor of the season, to say any tech solution, right? So is welcome. Any solution is welcome, whether it actually solves the problem or not, or whether that is even a problem or not, or what other problems that solution leads to.
Odni has a question. Can you explain how vehicle data is being there in ICJS is different from a policeman asking the details against a vehicle number from a scene of crime? So Okay, so the issue is not asking you details of where you were. Like, so if you're an accused or if you're a suspect in a criminal case, they have every right, part of the Evidence Act and part of, I guess Prasna can tell you more about the legal side or under the IPC to ask you details and you will have to submit it. But all of this is also when they ask you these details, they call you, they issue those notices. It's all democratic in nature. There is at some level both administrative and legal procedures that do take place, and it's all on record. But but what's happening in this scenario is there is no crime. Like if you look at the Telangana case, there is no crime, but they are stopping you on the streets because you look suspicious. You are heavily built. If you are heavily built, it's been a historic case in Hyderabad. If you look like a gunda, you are a potential gunda. So we will try to detain you, question you under the Gunda Act, under the prevention detention principles of the Gunda Act, right? So anyone who looks suspicious, I mean, if you look suspicious, if the police detain you, ask you to show your ID card, that's perfectly valid. But the issue is nobody trusts ID cards anymore because they have realized that ID cards can be gamed and they're like, no, we can't verify your ID card. Even the other cards that they said we will verify it because you all know what the problems are with verification around Aadhaar. They stopped trusting ID cards. So what they are essentially doing is they are like, we will extract information from the individual at the scene and we will try to determine who they are. It's nothing to do with us individual trying to identify who we are to the police. It's the police trying to identify who you are. And in this process, if they have access to your vehicle details, it's just not that they can determine who you are. They can also determine your travel patterns and where you have been through because of all the CCTV networks that are being now converted, right? Like I haven't mentioned that, but essentially when you're talking about 360-degree profiles, it's not just criminal in nature. It's also your personal details that are becoming part of the system. And I mean, I'm not even against this idea if you're trying to use this to solve a crime, but there is no crime here.
Yeah.
The violation is you are getting access to my details without a crime, right? Like it's against the whole idea of the Evidence Act. You only ask evidence when there is a crime. Without a crime, this whole idea of preventive detention or preventing a crime is being sent overboard now with these databases. Like in the past, if you were someone uh, who were supporting certain form of revolutionary ideas, right? You were detained for publishing a book or even conducting a meeting, conspiracy theories, all of that. You don't need any of those anymore for the preventive detention. All they have to do is that you have been at a particular location at a point of time accidentally where there was a crime, right? When they collect all the call data records, if there was a crime and they try to trace who are the individuals at the crime scene, they're trying to obtain call data records to determine that. Now, if you, by being part of these databases, they are able to determine every individual who was at a point of time at a particular location or at the scene of crime, and you are now a suspect. And the burden to prove that you are not actually the one who's committed the crime is on you. It's no more on the police to determine that you are the one who has committed the crime or to arrest you. You will have to go tell them that I was there because I was doing some other work. You will have to prove to the police official that you weren't there to commit that crime at that point of time. So this inverses the relation on between an individual and the criminal justice departments, whether it's the prisons or the police, right? Like if even if you're a journalist, say as a journalist you go interview someone in the prison, you are now part of the network, right? Like you visited a criminal, And that is something serious, because and what's also happening is the idea of the criminal justice system was always on okay it should be, rather it was never, it should be around reforms, right? Like you were trying to ensure that the individual who has committed a crime gets reformed when he stays his time in a prison and he comes back better back into the society by essentially tracking every prisoner, past prisoner, and even when he's on bail, by tracking all of his details, you're making it hard for an individual to be reformed, because the moment there is a crime, in case of Hyderabad, the Hyderabad police goes and catches the nearest guy who's a past known criminal from the who's just out of the prison. So, and that sharing of this information and harassment that, oh, you are the criminal, you are the potential accused, is going to be a serious problem, and it's just mere harassment of people. And we've witnessed this at scale in Hyderabad, part of the pilots. Thankfully, they stopped because of some criticism from the public. And nobody knows that this is happening, right? Especially the media. Whatever happened in Hyderabad is unknown. Whatever is happening within Delhi, for example, Delhi already has this. So if you're talking about the recent Delhi protests, and when you're talking about the facial recognition system, you're only looking at that. But it's not just these facial recognition system or fingerprint systems. It's all the other databases that are being interlinked to this criminal justice system that become evidence. And it's very easy to manipulate digital evidence, by the way. We are witnessing that. It's really easy to go change a lat long of my call data records to say that I was at a potential protest, even though I was never. Like, how would you verify that the digital evidence that they have is accurate, right? Like, there is no law around all of this is just becoming part of the judiciary and the cases, because the judiciary is actually recognizing the system without a law.
Yeah, that's
So I have
three or four points here, Rohini. Yeah, go ahead, Rohini. If you want to follow up that question, I'll.
Yeah, so everything that they get from this ICJS would now be part of like circumstantial evidence, or how does it play with, when he says it becomes digital evidence, don't they still have to put that together before they accuse somebody, or just having?
Yeah, I get your question. So I'll let 3 or 4 parts to this, right? One is, how does any crime investigation work? First, there is a complaint. There is something that is initiated, and therefore you're trying to pin down the responsibility for the crime to so many people if the identity of the accused is not known, etc., trying to see who did it. So normally, all of this data is collected by the respective people and it is kept in separate silos. Even to demand this data, you need to show you are actually investigating this crime for which you need this data. And then that data is provided to the police under a certificate under the Evidence Act, digitally. So this is, I am a responsible officer, for example, in Airtel. This is the call record data of this number that you have suspicion. This is how typically when there is a crime investigation happens. So where there's the safeguard here against digital planting, etc. here is that, see, the person providing this data, the Airtel officer, is not part of the police force. So therefore, there's no reason to doubt his credential, and he is issuing a certificate under his name, under the Evidence Act, under the oath, and therefore there's nothing to disbelieve him. Therefore, that corroborates the police theory that a particular person was there on the crime scene, etc. So you change this. So where there is real-time accumulation of lat-long data by the police, for instance, under the ICJS, there's still some doubt as to whether that is going to happen, but certainly the models suggest it will happen. If that is the case, so what happens is everybody is effectively a suspect from day one for crimes that are committed now, and for the crimes to be committed tomorrow and day after and next year, etc. So the police has all the information. So if there is a crime, if they want to link A to the crime B for whatever reason, they can do it just by a switch in their database. And that is what Srinivas was explaining. And whether we should distrust the police, should distrust the police. In fact, the whole point of the Criminal Procedure Code, the whole point of the criminal justice system, certainly in India, is distrust of police, which is why your statements to the police are not admissible in court, even if you have confessed to your crime. Which is the reason why there is the distrust of police is certainly a key aspect of our criminal justice system, and therefore you can't turn that on its head and say that, see, why do we need to distrust police? Of course, we need distrust of police is important. That's only in a process that has certainly distrusted the investigating authority. Only then, when a person accused is guilty of offense, then he is deemed to have received a fair trial under our system. That's one part. And the second part is this aspect of trying to pin down everybody as a suspect. So this came to be considered in our Aadhaar 5-judge bench judgment. So where, if you recall, so Aadhaar linking for bank accounts was to be done for all bank accounts mandatory. So there were rules passed under the Prevention of Money Laundering Act. The Prevention of Money Laundering Second Amendment Rules 2017 was passed, and that is what made Aadhaar linking mandatory. So these rules were struck down by the Supreme Court precisely for this reason. It says it's disproportionate to say everybody is a money launderer. That kind of presumption itself is unconstitutional. You'll have to presume everybody to be innocent and say and do as a non-restrictive a measure as possible to be able to catch money launderers. Right? That you don't have an efficacious method is not really an excuse for you to net everybody as though they are a suspect. So that's number two. So where the proportionality and whether you can even have this presumption of everybody being guilty or a suspect, that itself is unconstitutional. That is now settled. The third aspect, Srinivas very briefly touched upon it, where you say, in our criminal justice system, and completely across the civilized world, when you do a crime, you do the time. That's the philosophy that we. But here, what is the time? The time is, in our constitution, it's punishment, and it says so you don't get punished more than what the law had prescribed at the time you had committed the offense. If at a particular point, 7 years is the maximum punishment, example, for murder. Right? Subsequently, it is changed to life imprisonment. But when you committed a murder at a time when the punishment was merely 7 years, you can only be punished for 7 years. That's actually an express guarantee under Article 20 of our Constitution, where you are not punished longer than what it was the prescribed punishment at the time you committed the offense. Right? It's called ex post facto. No ex post facto guarantee. So here, what happens is now, because you now have this trail being followed, you've been traced throughout your life. Your time even if somebody is is guilty of an offense under the Act, once he serves the sentence, he is entitled under the law to start his life afresh. Nothing of that really should stick. Right? So, in fact, if that sticks, then really the punishment is not really what is prescribed under the law. Right? You need to give that. So, it's not really just reformative as Srinivas put it. Of course, that is there, but also because that's the guarantee, that's the civilizational guarantee that we give. So, we're a civilized society. We don't punish for more than what is required, what is prescribed under the law. Right? Anything, even so, what is a punishment? Punishment, when you say put somebody in jail, what does it mean? You are effectively depriving that person of valuable rights under the Constitution. You are depriving that person of right to free movement. You are depriving that person of right to of liberty. So similarly, when you actually take away that privacy for entire life, it is as good as life imprisonment, because you're depriving the person of that right for the rest of his life. So that's another aspect. So where it also is a violation of Constitution if you are effectively storing the person's data. I mean, even if somebody is guilty of it, so you try and record that forever and use that and net him as a suspect for any further crime, etc. So where, in fact, I mean, it's been there since time immemorial. Police stations have what is called history sheeters, and now we also have people advancing this sex offenders registry, where anybody who has ever been accused of a sexual offense, sexual harassment, or sexual assault offense gets into this registry, and therefore it's there for people to look up and be careful about them or whatever, right? So even that again will be a violation of that guarantee under Article 20 of our Constitution. Yeah.
The issue there again is that you don't know if the guy, again, this is not to support any sexual offender, but you don't know if there was a crime or if it hasn't been. You don't know if he was a criminal or he's an accused. He remains an accused forever, because you don't know that you're part of the system, and you don't know if you can get out of the system. And this is very problematic, especially for the LGBTQ community, who are routinely harassed by the police in India, right? So there are challenges to these unilateral identification of the state of individuals saying that this person is a sexual offender because he dresses as a transgender, right? Like, that can't be the basis, but unfortunately that's the basis, because we've seen enough police departments wrongfully accuse you of crimes, and it's an harassment that's always been happening. And the issue is, we don't know to what extent these systems will enhance it further, because you could be part of these systems and you would never know why you were part of these systems, because you will never know you are already in the system, because all of you have a driver's license, right? Like, you are in the system and you never knew that you were in the system. It was the case for Telangana individuals too, right? Like, we had no idea that the state has created this new digital ID system based on facial recognition, and the police has access to all of this. And the reason we are discussing this now is also that because 2 days ago, the Parliamentary Committee on Personal Data Protection actually held a consultation with the officials from the MHA. I mean, there are reports from Media Nama and elsewhere from PTI, I guess, that the MHA, NCRB, Registrar General of India were all lobbying for them to be exempted. And the exemptions are primarily for these national databases. I mean, in case of the Registrar General of India, it is for the National Population Register, also which will be part of this. Like, when you're talking about immigration data, the immigration data comes from the Registrar General of India as well. It's all centralized at the MHA, but what you're witnessing is interdepartments within the MHA and outside are sharing this information, and they all want exemptions for it. The problem, though, is all of this needs a separate law in itself. I mean, that's the whole thing the Fundamental Right to Privacy judgment talks about. And even in case of the Aadhaar judgment, it outrightly says that this idea of 360-degree profiles itself is flawed, because not only they say that Aadhaar cannot be used to build this system, saying that if at all those systems will be built, they are unconstitutional, is what, or they become surveillance, is what they recognize in their judgment. Okay, I have
There's another question from Rahul.
Yeah. So do you know whether these systems, databases, logs, when data was added, altered, who did it? Okay. So essentially, Rahul is asking me this, like, if someone in the police department does a search trying to identify me, will there be a log in the police department? They don't have to tell me necessarily, but will there be a log when there was access to my information, and whether that information was also changed? So I was talking about the scenario, right, where someone could change my location data inside these databases and can accuse me as a potential criminal, right? most of those people who were arrested in the Bhima Koregaon case were that. Essentially, they were nowhere in Pune during the Bhima Koregaon case, but they're all like, you guys orchestrated this. You were the ones who plotted this. You created unrest. You were planning to kill the prime minister. So the evidence can always be fabricated. Now, if such a digital evidence was fabricated, there is no way to know it because the logs are always with the government itself, whether it's the MHA in this case or the other departments. In case of Vahan, it's the Ministry of Road Transport. And there has never been the concept of producing logs. Like in case of the Aadhaar case, I think that's the first time we saw that the UIDI CEO actually produced his logs from the UIDI system. But he never had to do that. It was a voluntary decision that he took to produce to the court that, look, this is what we collect. But there is no requirement under the law to actually produce these because there is no law. And also because we don't entirely know about how these systems are being made, you don't know the accountability checks that exist in place. Right now, I can tell you for sure that the Telangana systems have no accountability. Whether it's governance or even in terms of technology, it's the police who are always in control, and you're looking at a very dystopian idea here when the police become the boss. It's not just the home minister or the judge or the essentially officials, representatives, but it's actually the police who is going to rule the society, and that's a very dangerous scenario that we need to watch out for. Anyone else has any more questions? Okay, I have to check if there are other questions on YouTube. Okay, I don't think anyone else has any questions. But okay, we can end it here. If you want to know more about this, see, anything that I said is actually taken from official documentations from the MHA, from various departments, police departments, and it's all available in the registration page. So if you have registered for this event on discussion on the HasCake website, you can find all the presentation by the NIC to MHA. You'll find RTI filings, notes of MHA, and you will also find a couple of NCRP papers on this. There is a paper where the NCRP actually, one of the presenters actually talks about what the system's going to look like. It's from the NCRP Journal of 2019. So where they only tell you to, which is where I found out that they plan to integrate immigration and passport data into this. So you can check those details, but you can also join us on a public Telegram group. The link is t.me/KAARANA, KAARANA. It's telegram.me/KAARANA. Okay, there is one question on the YouTube. I think Satya Prasad, he's asking, does it make sense to have a central authority who is custodian of this data and frame laws around how and when access should be granted? Prasanna? So if all of this is digital evidence, how do you manage this? I mean, if you're entering to that phase of saying you will have to build such a system, you will have to monitor everyone. I don't think our laws would allow that. So does it actually make sense to create such an authority to look at evidence?
No, so that's effectively you are creating a single point of failure, right? So what is bad technical architecture is also bad legal architecture in many ways, right? So it is a single, then you are effectively creating a single point of failure. You're effectively creating a honeypot, right? So that can effectively be hacked to hack the entire process. So why would you want to do that? So what, in fact, in many ways, in how our evidence system works is to be able to corroborate. So when A says something, in support of A saying it, if he is able to get B to say the same thing, C to say the same thing, and D to say the same thing, B, C, and D are effectively corroborating what A is saying. But if you have everything as one central certifying authority, what you're effectively saying is that you don't even need further corroboration. You just accept whatever that one person says as the be all and end all. That's more than anything else, that's imprudence. And if that is an evidence, in fact, you won't be able to even convince a magistrate or a sessions judge that you've effectively proven that a particular person has committed a crime, even if you create that one certifying authority.
So
in fact, it is in the interest of law enforcement that there are several authorities collecting their own data in the usual course of business that they do for their purposes. And if there is a crime, that gets used on demand for the purpose of investigation of that crime in order to solve that crime. In fact, it's in the interest of both law enforcement and the citizenry to have it that way.
Okay, I have this question to you. The recent judgment in the Supreme Court on the idea of electronic evidence, right? That if electronic evidence is being collected from you, unless you are provided with the certificate 65B, if I'm not wrong, that evidence will not be considered to be judicial evidence at all. Now, to what extent would that apply to this entire system?
Well, so that's, in fact, I say that it would fall foul of that judgment, where you say, so that judgment effectively says, if you are collecting electronic evidence and say that the contents, the copies that are submitted to the court is actually the correct version of the electronic evidence that was as collected at the time it was collected. So you say there has to be somebody responsible who was in charge of those copying systems and in charge of those systems that collected that evidence to say, yes, this is in fact the correct copy of that original document that was collected at that time. So this is what the contents of the 65B certificate included. So Supreme Court has had, it has had ups and downs. In fact, in Afzal Guru's case, it held you don't need to collect that certificate contemporaneously. If you had not collected that certificate, it is all right at the time of trial. You summon that officer, and the officer is at that time, at a later time, able to confirm that the contents are in fact proven, actual copies of the original that was collected at that time. So this changed in Anwar versus Bashir later on, many years later. In fact, a trivia that you may want to know is that in Afzal Guru's case, the question was about the call data records. As you know, in Parliament attacks, so when the Parliament of India was attacked, all those gun-trotting terrorists who had attacked Parliament had been gunned down on the spot. So, in fact, the whole thing of connecting the conspiracy to that event was call data records, suggesting that Afzal Guru had been in touch with those who attacked Indian Parliament. So these call data records were in question. In fact, in my reading, that was the only evidence that linked Afzal Guru to the Parliament attack. And those call data records, the question before the court was whether those call data records were admissible in evidence in view of 65B, because there was no 65B certificate that was validly obtained under the Evidence Act at that time. So they said, no, so now we can summon at the time of trial, even though, there was no valid 65B at the time you collected the evidence from the telecom companies, etc. Now we can summon those officers and let them certify that it was in fact correct. So this question of admissibility, whether that kind of evidence without 65B certificate, which came to be overturned. So the Afzal Guru's case was expressly overturned. after Afzal Guru had been convicted and had also been executed by that time. So it was overturned in Anwar versus Bashir, saying that 65B contemporaneously at the earliest and has to be produced before the court. So there was a confusion in a later case that said it was Anwar versus there was next what is called it was Anwar versus, but she was incorrectly explained in a later case. That explanation has effectively been set aside now in the most recent judgment. So the Anwar's position more or less is the same. So in electronic evidence now 65B has to be scrupulously followed at the time of evidence collection. The police will also need to collect the 65B certificate from those authorities that give them data. For instance, now, if there is a crime investigation, if police are collecting call data records from your mobile service provider, the mobile service provider they need to give the call data records and contemporaneously give the 65B certificates to them. To the police. The police failed to collect the 65B certificate. The admissibility of that those call data records at later point during the trial will be questioned.
I don't think any of that is actually signed cryptographically to say that the evidence wasn't changed, but let's see how this will happen and how 65B gets implemented over time. But Rohini has one more question. Would there not be a way for police using it only access or enter information only in an investigation, or a judge to access the info only if they enter the case number? So the essential question is, what kind of access limitations would exist? In terms of cross-departmental access, like the judiciary may not have access to my call data records, but because this data is being centralized at the MHA and the NCRB, the part of CCTNS. So it's essentially an evolution of CCTNS, right? This is an entire MHA database, and it's the MHA which is giving access to the judiciary. At the same time, getting access to the court records, but I don't think that the MHA actually needs the court records that way. It's more interested in personal information. So the access limitations for MHA does not exist, and that then they're lobbying for there should be no limitations at all for the MHA, part of the privacy data protection bill, because if there are any restrictions or any oversight, forget restriction, even for all of this process, if there has to be an oversight by the judiciary on ICJS, right? Even they're lobbying against that. Like, that's something the Justice Sri Krishna committee proposed, right? There has to be some judge who has to authorize this access to this data, right? There has to be judicial procedure. And that was overturned essentially by Ministry of Electronics and Information Technology, part of the current bill. And the Joint Parliamentary Committee is also being lobbied to further bring it down to essentially ensure that MHA has no limitations and they could do whatever they want. But unfortunately, that's not how it should work. So, it's important that the Data Protection Bill and the Joint Parliamentary Committee looks into a lot of these 360-degree profiles. It's not just at the MHA, because when you say exemptions for government, it's not just for the Ministry of Home Affairs. The exemptions apply to state governments and to other departments as well, which are also trying to build larger other 360-degree profiles for welfare databases. But and the MHA benefits in all of this because they have unlimited access to all of these other databases as well. So,
I think the larger issue is the structural dependence, right? Particularly, it is grave. It's for the judiciary to depend on a government of India system like this. As it is, our judiciary is dependent on the government of India for a lot of things. That compromises their independence in many ways. For example, they are reliant for several things. For administration, they are reliant on the government of India. When government of India is the largest litigant before the Supreme Court, right? one great example also, in fact, if you see, Supreme Court of India is theoretically independent of the government of India because they are both co-equal constitutional authorities. Supreme Court is arguably a higher authority than the government of India because it's also the guardian of the constitution. But the Supreme Court website now, the link is sei.gov.in. Right? So it effectively, So similarly, so for all their IT purposes, relying on government of India is a recipe for disaster for citizens' rights. Right? I mean, if they say, I mean, as it is, we are moving towards a place where whatever the government says is taken at face value without cross-examination, that is a major issue that we're facing with our constitutional adjudication now. And that is going to be aggravated if all our IT systems that the judiciary uses are completely at the control, at the beck and call of particularly a body like ministry like the Ministry of Home Affairs. And it's a structural issue. It's not just a functional issue. It's a structural issue in terms of, I mean, there may not be any conspiracy. MHA, for all we know that, I mean, they may actually discharge their duties perfectly well with no malice intended, so no malefides there, etc. But it's not just a functional thing; it's a structural thing. So if the government, so that the judiciary to be independent of the government in as many ways as possible, it's a structural goal. Is a goal that we are towards, and this is a significant setback to that.
And the issue in terms of this idea and models of these databases, right? So they all say or claim that they are the single source of truth. So single source of truth is an information model that has kind of come up again through the state resident data hubs at some level from Andhra Pradesh. That's what I could track to, but we really don't know. But it's used everywhere now. The NITI Aayog pushes it. They call it like Arogya Setu is the single source of truth for COVID. Whether you're COVID positive or not, Arogya Setu will be the single source of truth. The MHA claims ICJS will be the single source of truth to identify a criminal in the justice system. So everybody wants to propose their own single source of truth, but all of these single source of truth, for that to emerge, they all need all of your personal information to build 360-degree profile databases. So, and these 360-degree profile databases are emerging everywhere. Everyone cites our model is better than their model, like the MHA's model is better than the Telangana State Police model, or the Department of Rural Department can say that, look, we have a better welfare model, which is better. At the end of the day, the experimentation that's happening because of solutionism and protectionism and this whole idea of national security or whatnot is really concerning, because you have agencies like the NIA, the National Investigation Agency, which is claiming they need all of this to basically track terrorists. If you looked at the slides of ICJS, you would see that NIA is mentioned. Now, the NIA, which is tracking the Prime Minister's threat to the Prime Minister or going around the Bhima Koregaon case, is unable to provide any evidence. And the entire evidence for the case that they have is a lot of terabytes of digital evidence, which potentially leads to that it has been planted. The questions on how much of the evidence is true or not. So this is really challenging, especially when UAPA is being imposed on everyone, including for sending emails, right? So this is really problematic if they start trying to trace your web IPs and start trying to trace everything from ICJS, and you become part of the criminal justice system just because you sent an email to the minister, is really concerning. So the amount of power that information is leading to these agencies is what that we're trying to question here.
Yeah. I mean, single source of truth. I mean, the necessary implication is that you are erasing all other sources of truth. You are eliminating all other sources of truth, right? Either as gaslighting, saying they're all false, or just say, they're just not feasible to even collect them. And so therefore there is, deeply problematic even at that level, right at the level of conception.
Okay, I think we will end it here. Uh, if you have any questions, just join the Karna public group and you can ask me or Prasan any questions. We're both there. Yeah. Thank you everyone for joining us.
Thank you all.